Hello, and welcome to the November 20th edition of Success by Association Live. Today's issue is sponsored by Riverfront Convention Center of Craven County and Jordan Price Law Offices. We thank them for their support of AENC. Today's article is written by Holly Peterson, counsel with Tenenbaum Law Group, and is reprinted with permission. The article is titled, Nonprofits and AI, Managing Legal and Other Risks. Generative artificial intelligence, or AI, is ubiquitous. Even those most skeptical of AI almost certainly use AI as a matter of routine, whether through the spell check feature in Microsoft Word, the autocorrect feature in text messages, the autocomplete feature in various applications, web searches, closed captioning, digital traffic maps, smart home devices, suggested responses on Gmail, Siri, and so forth. At this point in time, it is not realistic to imagine a business where AI is not used in some form. Even so, nonprofit organizations should carefully weigh the benefits of AI against legal and reputational risks. For example, a nonprofit may wish to authorize the use of AI to capture committee or working group notes, but might there ever be times when such authorization is imprudent? For example, if a committee or working group is discussing sensitive, confidential, or proprietary information. Consider another example where a nonprofit uses AI to assist in the peer review of a journal article. This could be efficient and highly valuable, but it also could prompt legal, reputational, or scholarly concerns. As technology evolves, AI will become more and more intertwined into the fabric of nonprofit operations. Nonprofit leaders should thoughtfully consider the promise and perils of AI with respect to their organization's specific needs and should thoughtfully craft policy and practice that is tailored to the nonprofit's specific needs, all the while managing legal and reputational risks and aligning policy with accepted practices, industry standards, and strategic aspirations. This article outlines legal, reputational, and other risks related to AI and outlines some strategies for managing those risks. 1. Primary risk areas. While the promise of AI presents transformative opportunities, the use of generative AI presents legal and other risks that must, and can be managed. Primary risk areas include intellectual property ownership, use and infringement, privacy and data security, discrimination, and tort liability. These risks are born from a complicated web of evolving federal, state, and international laws related to privacy and data security, and to a lesser extent to AI itself, that in many ways intersect, but that all have various nuances. In addition to legal risks, AI also may present reputational risks. While the potential risks are significant, appropriate risk mitigation measures can reduce both legal exposure and reputational risk. Who owns the copyright to AI-generated content? The U.S. Copyright Office will only register an original work of authorship that has been created by a human being. The office's compendium of Copyright Office practice clarifies that the office will not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author. To evaluate ownership claims, the office will look at whether the work is basically one of human authorship, with the computer or other device merely being an assisting instrument, or whether the traditional elements of authorship in the work, literacy, artistic or musical expression, or elements of selection, arrangement, etc., were actually conceived and executed not by man, but by a machine. The U.S. Copyright Office reaffirmed this position most recently in an August 30, 2023 call for comments published in the Federal Register, but in so doing, acknowledged the inherent challenge in discerning between AI-generated content and human-generated content, especially when a new work had both human and artificial imprints. As it reflected, although we believe the law is clear that copyright protection in the United States is limited to works of human authorship, questions remain about where and how to draw the line between human creation and AI-generated content. AI ownership is a novel and rapidly evolving area of law. Based on existing law, nonprofit organizations should assume that they have no intellectual property rights in and with respect to AI-generated content. As a matter of course, nonprofit entities should require human authors to substantially and materially contribute to any nonprofit work product. Nonprofits should revise existing author and speaker agreements, both for volunteers and paid contributors, to require a written attestation from employees, contractors, and volunteer authors and speakers representing and warranting that any submitted content has been revised substantially such that the author-creator has all necessary rights to assign or license the work to the nonprofit, and the submitted content does not infringe the intellectual property rights of any third party. As discussed later in this article, that same attestation should also address defamation, privacy, and other third-party rights. At least for paid contributors, the author-creator should indemnify the nonprofit for any breach of these representations and warranties. What third-party intellectual property rights exist that could be leveraged into an actionable claim against a nonprofit for the improper use of AI? Under U.S. copyright law, a copyright holder has the sole and exclusive rights to create derivative works from the underlying copyrighted work unless the author assigns or licenses that right to a third party. Derivative work is a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art, reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. Assume that an author-contributor submits an original work that relies in part on AI-generated content, and that the nonprofit publishes the work on its website and distributes the work to its members. Assume also that the AI-generated content that is embedded in the submitted work infringes someone else's copyright. It is possible in this circumstance that the third party whose copyright was infringed may have actionable claims against the author and against the nonprofit that published and redistributed the work. Ultimately, an infringement claim will hinge on the facts, focusing on the extent of the infringement, as well as an analysis of whether the appropriated content amounts to permissible use under the fair use doctrine. The factual analysis, though, is hardly simple. Even the U.S. Copyright Office is not certain how to distinguish new works from derivative works when AI is used in the development of a work. They have asked for public input on whether or when the use of copyrighted works to develop data sets for training AI models in both generative and non-generative systems is infringing, the proper scope of copyright protection for material created using generative AI, and how liability should be apportioned for AI-generated content that infringes upon a copyright. As before, risk can be mitigated by requiring human authors to indemnify the nonprofit for works that infringe upon third-party intellectual property rights. Indemnity essentially transfers risk from the nonprofit to the submitting author, thus protecting the nonprofit from any liability that might arise from third-party intellectual property claims. That being said, for volunteer authors, it often can be difficult to get them to agree to such indemnification. What are the legal risks of using AI with respect to privacy and data security? Nonprofit organizations' use of AI, while embedding great promise, also carries substantial risk, especially with respect to privacy and data security. AI relies on inputted data to generate new data. It does not differentiate between public data and personally identifiable information, or PII, or confidential information. Because PII is so heavily regulated by federal, state, and international law, nonprofits should not allow staff, contractors, volunteer contributors, or other agents to input PII into an AI application unless comprehensive compliance measures are implemented and enforced. For other reasons, namely to safeguard confidentiality, proprietary, sensitive, and or attorney-client privileged information, nonprofits also should prohibit staff, contractors, volunteer contributors, and other agents from inputting confidential, proprietary, or sensitive information or privileged content of any sort into an AI application, even if the sharing or learning feature of the AI application is disengaged, as can be done with paid and enterprise versions of most of the leading AI platforms. If it is not possible or practicable to segregate PII or other confidential information, for example, if a nonprofit uses targeted advertising to tailor member or donor experiences, the organization should implement additional risk mitigation measures to comply with federal, state, and international data privacy laws. While each of these laws contains various nuances, in general, these robust laws derive from a uniform set of principles that endeavor to protect PII from unauthorized disclosure by 1. Requiring organizations to obtain informed consent prior to collecting and using PII. 2. Requiring that organizations provide an opportunity for individuals to change their preferences at any time about whether and how their data will be used. And 3. Requiring organizations to provide a mechanism for individuals to access personal data. A robust privacy and data security policy, coupled with aligned organizational practice, can help to mitigate liability for a data breach. Where a nonprofit relies more heavily on sensitive PII, we recommend engaging expert privacy counsel to 1. Determine applicable data privacy laws, 2. Review and classify all existing data that may be used by the AI application, 3. Identify the purpose and use of the data in a clear and articulable way, 4. Develop a compliance plan, and 5. Monitor compliance over time and take appropriate action in the event of noncompliance. This article is concluded with Part 2.